Original side mentioning any?
Today there's no mentioning, madam. The dates are fixed for mentioning. Original.
Particular side mentioning.
Yes, tell me.
Find the matter of 8 March. Illegal construction and the property is dilapidating. The property, the ceiling of the ground floor has collapsed. Also annex a picture. It is not come in the lease.
All right, give it.
Illegal construction.
Illegal construction.
One of the kind.
Maybe I just to mention one item for inclusion of your lordship's daily list, my lord. It was filed against the Kolkata Municipal Corporation, my lord. My lord, we are running an authentic Bengali cuisine, and my lord, we have an agreement with the landlord. We are regularly paying the rent. Suddenly, Kolkata Municipal Corporation, they have sent a notice that that we have to pay rupees 23 lakhs. Otherwise, they will close our shop as the tax
For the conversion charges.
My lord.
The conversion charges.
My lord, there was no agreement with no, my lord, only property tax, not conversion charge, my lord. Property tax we have to pay to the Kolkata Municipal Corporation. We have sent several requests to sit with us, my lord, for giving up.
Go before the municipal valuation.
My lord, yes. My lord, we have tried to go there, my lord.
Then?
My lord, we need a proper chance of hearing only. That's all, my lord. We are not.
Go there, you have a
My lord,
chance
we
of
have
hearing.
done on several occasions, my lord. Otherwise, they are threatening that they will close our shop.
No,
We
what
are
is the
ready to
problem with the municipal valuation?
My lord, they are not allowing, my lord. We have sent several notices. We want 5 minutes, my lord, from your lordship. Kindly, my lord, on any date, my lord. Grateful. Grateful, my lord.
What is the matter? You appear for the corporation, don't you? You can do both.
Item number 125. There is some urgency in this matter because your unauthorized
Where's
construction.
the other side?
Other side is there, my lord.
Is he there? In front of you?
My lord,
Do not mention, sir, without.
only one thing, my lord. Your lordship kindly.
Sir, do not mention the matter without the other side. Yes.
One of the kindly.
My lord, may we permit to mention appellate side matter, my lord. My lord, we recall, my lord, on the last day, your lordship have mentioned.
Appellate side no mention.
One of the kind leave. Item number 206 of your lordship's list. This matter was mentioned.
The other side.
KMC, because I am with.
Yes, KMC.
We have already served it. I'll
mentioning without the other side being here.
only the difficulty if your lordship
sir.
fix it. I'll serve it and I'll.
No, sir. Get them here.
Very well.
Original side matter regarding unauthorized construction. There is a instruction to demolish 3 plus 3, G plus 3 storage building, but instead of that, the KMC has demolished the adjacent shop room.
My lord, may I be permitted to mention a matter? I'm the owner of a property in Shambazar.
Original side.
Original side, my lord. I'm the owner of a property in Shambazar, which is in an extremely dilapidated condition. I've received a notice under 411 KMC Act. I have engaged an engineer who has come and said that this building needs to be demolished and reconstructed. It is filled with unauthorized occupants, and KMC is not taking any action in spite of writing to them multiple times. I'm seeking, my lord, another matters of similar facts, 2 matters.
Original side matter, item number 1 for judgment.
In view of the detailed discussion herein above, this court is of the considered view that the decision rendered by the arbitral tribunal wide award dated 16/2/2018 and 5/12/2018 are judgment in personam arising out of private dispute and is not binding on a third party. The respondent corporation being a third party to the said arbitral awards, this court finds no infirmity or illegality in the stand taken by the respondent corporation. In view thereof, the present petition is dismissed. But you argued well. ये
Next.
चेंज होगा इसमें गैप नहीं आया है ठीक है इसको वापस अभी डाल दो चेंज करके फिर साइन वाइन करेंगे और कुछ चेंजेस कॉल आउट द लिस्ट
Item number 2.
Very last order.
Court application under Article 226.
Well, I appear for the respondent. Huh? Huh?
Where's the order sheet in this? There was certain direction, Mr. Ghosh.
My lord,
There were directions
directions
upon you
in this case, my lord.
in this case.
My lord, as I understand, my lord, the so my knowledge goes, my lord, this matter, my lord, was heard by the coordinate bench on earlier occasion. Thereafter, possibly, if I'm wrong, my lord, the appeal was taken out. Of course, my lord, I'm not sure today, my lord, about this, my lord, because he's asking for the addition of parties in this case.
On 19th April, there's a direction to the executive engineer to file an affidavit.
My lord, if I may. Disconnect the power for Chilo door actually. বলতে পারছিস না কারণ এটা দেখিস না কেন
Which is the order?
My lord, if I may assist the court, my lord. Today we have come before your lordship for the sole and sole reason, since the impugned order had directed against the demolition of our premises number 20A. On the basis of that, the petitioner has not made out a case against us by not making us a party from the start. We are the bona fide landowners mutated by the KMC itself. We have a valid sanction plan, but we have been waived off by saying that we have constructed illegal unauthorized demolition, unauthorized building on the same premises number. That's why we have come before your honor to seek justice, because we haven't been heard outrightly from the start. Our side hasn't been presented before your honorable court, that what is our right. We should also present that if there is a illegality on our side, we should come with clean hands before this honorable court.
I may request you to your lordship, my lord, because I understand, of course, my lord, the 7 numbers of premises are there. The 19th April, my lord, the order, my lord, speaks of unauthorized construction, certain directions are there. In certain cases, my lord, the appeal was taken out. So far as this case is concerned, my lord, if your lordship, my lord, gives me some time, my lord, next day, my lord, I can, my lord, check up the records and, my lord, assist your lordship, my lord. What is the 7th May, I had submitted a report before the honorable court. After that, my lord,
My lord, if I may. My lord, if I may.
Yes.
The report, there are very, very strong allegations in the report in which we have been directly pointed out on record by the KMC that we have no sanction plan, whereas we have already written it that we have a valid sanction plan given by the KMC. We have mutated our names under the records of the KMC.
20 তোমার কত নম্বর পেয়েছে
20A
20
20A
এখানে দেওয়া নেই কোথায় 20 এখানে আছে কোথায় 20 এই যে নাম্বারগুলো আমরা দিয়েছি কোর্টের সামনে
বলো কোথায় এটা
এইটা আছে demolition premises under section
এই তো আমি রিপোর্টটা বলছি My lord, kindly see page number 9 and point number 9, in which they have given a report regarding the departmental inspection of the same. 20A has been mentioned. If I may read to your lordship. Department inspect 20A Tiljala Road, Kolkata 700046. Department inspected the premises. PR has been constructed 4-storied RCC structure without any sanction plan. So the department has issued stop work notice under section 401 of KMC Act on 15/9/2023, and the local police has been intimidated for the same. The matter has been processed under section 400 of the KMC Act.
এগুলো এসে গেছে।
Mr. Ghosh, you have to file a report.
Well, I'll check it up records, my lord, because as I remember, my lord, certain things had happened after that order, and in certain cases, appeal was taken out. তোমার কথা বলছেন, অনেকগুলো premises
You
ছিল।
have taken time to comply with the order dated 19th April. It's been more than a year.
But after 19th April, another report was filed before the court. That is on 17th
You
May.
file the report. Learned counsel to the
My lord, I kindly, if I may please the court, kindly help us to add us as necessary parties, as necessary respondents, so that we come with clean hands before the court.
You're not required, sir. You go before the authority concerned. You're not.
Much obliged. Much obliged. Grateful.
Learned counsel for the respondent corporation seeks to file the updated status report indicating the demolition action taken upon the unauthorized construction. Full stop. He seeks how much time? 2 weeks?
2 weeks.
2 weeks time to file the said report upon inspection. Let this matter be listed.
Item number 3.
It's my application in a writ petition. I am for the respondents. This matter is of serious consequences.
I'm led by Mr.
Yes. This matter,
Who are you?
I am for the respondents, the tenants.
Yes.
In the original writ petition.
Let the
Now,
petitioner present his case. Let the petitioner present his case.
Yes, yes.
Let the petitioner.
It's my application. I am the petitioner.
Your
Yes,
application.
yes.
Which is the application?
And this here is my application. Now, the tenants, have been ousted, and the
Before
entire
starting
premises
the
has been,
submission,
demolished.
please,
The garb of,
I have certain
Yes, sir.
objection
May I?
regarding maintainability of the petition.
may I, sir?
There
May I
is-
complete?
But I have
Now-
objection regarding maintainability of the writ petition.
well.
See page 61, writ petition has been disposed of.
Very well.
A disposed of matter,
Yes.
Yes.
This can, this is a
61.
continuing cause of
Just a
action.
minute. Yes, tell me, sir.
page 61, the writ petition has been disposed of. Contempt is pending.
Just a minute.
In a disposed of matter,
Show me, sir.
I'll-
Read the order. What is it?
page
Well, I am
61.
reading. Kindly take page 61. What is the order and what, why it is maintainable? These grounds of maintainability, it's a continuing writ petition where, contempt proceedings are pending. Now, what has happened?
Just a minute, sir. Yes, tell me, Mr. Chaudhary.
My lord, the writ petition has already been disposed of. They have prayed, but kindly after going through the order, kindly see their prayer made in page 16. The writ petition claiming to be a tenant and occupier of premises number such and such, raised for a direction upon the corporation to implement the notice issued under section 411(1) of the KMC in respect of premises number 117. The owners and occupiers of the dilapidated structure have been implemented as private respondent in the instant writ petition. According to the writ petitioner, there is a common passage in between premises number 115 and 117. The petitioner apprehends that in the event the dilapidated structure collapse, then there are chances that the user of the premises number 115 may suffer an accident. Reference has been made to a civil suit filed by the owners. Owners mean here the respondent petitioner herein. City Civil Court, Calcutta, praying for order against the Kolkata Municipal Corporation. The petitioner is not a party in this said suit. The attention of the court has been drawn to the order dated 17 January 2022 passed by the learned court in the aforesaid suit, whereby the defendants were directed to maintain status by taking no step in terms of notice dated 10th January 2022, so that the occupier portion of the plaintiff in the suit property do get demolished, and that the defendants be ousted from the suit property without any due process of law or without granting prior opportunity of hearing. It has been submitted that two of the occupants of the suit premises number 117 have already issued no objection for proceeding with the demolition work. The notice dated 11th January 2022 was issued under section 411 of the KMC Act, intimating the landlords, occupiers, as well as the agency appointed for demolishing the dilapidated structure, the date of demolition. Petitioners' only play at this stage is to direct the corporation to afford opportunity of hearing to the owners and occupiers of premises number 170 so that the demolition of the dilapidated portion can take place. Learned advocate, representing the private respondent 4 to 11, now here is the respondent's petitioner, submits upon instruction that the civil suit is pending consideration before the learned trial court, and the corporation ought to take step in accordance with the orders passed therein. The learned advocate representing the corporation relies upon the instructions forwarded by the sub-assistant engineer, civil and executive engineer, civil, building department, Borough 4 and 5, signed on 9th December 2023, wherein it has been mentioned that the building was declared as dangerous building, and notice under section 401(2) of the KMC was issued on 6th January. Should I place the operating portion? The writ petition stands composed of by giving certain direction. Now, can you see the prayer in page 16?
Yes. He has not read.
In a disposed of matter, an order restraining the respondent numbers 1 to 3 to not evict the dispose of the applicants from the scheduled premises more fully described in Annex A herewith without due process of law. Their case is the civil suit is pending.
Yes.
But the abuse of the process of court.
May I?
Yes.
May I? My lord, he has read the entire order, but he has not saved except page 64. Kindly read, my lord, comes to page 64.
Yes.
Kindly comes to, my lord, the third paragraph.
Yes.
It will be open to the corporation to take necessary steps before the learned city civil court if occasion so arises for obtaining enabling orders so that consequential steps pursuant to the notice dated 411 may be undertaken. Millard, the writ petition was disposed of only Millard directing the corporation to go and Millard take steps in my suit, which is much prior to the writ petition, to take steps there by filing whatever Millard pleadings they want to. Now, Millard, corporation did not take any steps. Now, Millard, coming back in content petition, Millard kindly sees the Millard order, passed in the Millard the content petition at page Millard 158. 158. না না কাইন্ডলি টেক্সট পেজ 64 ভুলভাল পেজ বলিস না কিছু বলতে হবে না পেজ 65 নেক্সট পেজ let a copy of the let a copy of the contempt be served on the contender such and such. I am not the contender. KMC is the contender. Let it be recorded that the position of the structure has been reported to have collapsed, injuring 2 persons. No FIR, no complaint. The debris of the portion which is collapsed is blocking the pathway of the petitioner. The concerned executive engineer shall take necessary steps to forthwith clear the debris so that the pathway can be used by the petitioner and other co-occupiers. Now, kindly transit with the next order, 67. Here comes Millard, how Millard the scope Millard was enlarged. Now, Millard kindly take the third paragraph. Officer in charge, Barabazar police station is directed to render all necessary help and assistance to the men and agents of corporation at the time of removal of the debris and at the time of dealing with the dilapidated portion of the subject structure. Now, in the garb of this, we are several tenants. Now, entire structure has been ransacked. Now, today, the suit is pending. Kindly take the injunction order of City Civil Code, page 20. Page 20. I'm not reading the entire order. Kindly comes to page 22. Third paragraph starting with the word under the circumstances. 32 third paragraph. 22, sorry. Order, third paragraph starting Millard with the word under the circumstances. Has Millard. Under the circumstances of the case, considering the urgency of the matter, this court is of its opinion that the prayer for an ad interim order may be allowed in favor of the plaintiffs. I am the plaintiffs. Accordingly, the defendants are hereby directed to maintain status quo by taking no steps in the notice date. This is a 411 notice issued by the engineer, executive engineer such as KMC, intimation for demolition, so that the occupied portion of the plaintiffs in the suit property do not get demolished and of the defendants be ousted from the suit property without any due process of law or prior to getting any opportunity of being heard. And these ad interim orders shall remain in force for a restricted period till the date of the defense of such and such is still in continuation. Now, Millard, coming back to this High Court, Millard, this entire order has been nullified. And Millard, I have been ousted, Millard, and Millard, the property, Millard, where my tenanted portion has also been demolished. Millard, today, Millard, what I am claiming, Millard, KMC is a party here in civil suit. The order is passed against the KMC. This is the subject 411 notice. Millard, this notice is stayed. Everything is stayed. Now, Millard kindly takes Millard another order of the civil court where Millard direction was also passed in presence of parties allowing me to repair. Kindly takes Millard the 24, next page. On contest, 24. This is also prior to writ petition. Defendant number 6 is, well, may I read from the third paragraph? Defendant number 6 is contesting and the learned advocate appearing for on behalf of the defendant number 6 has submitted that he has no objection if necessary repair is done. It is submitted that other defendants have been fully served, thereby not contesting. Having heard both the sides and having considered the necessity of repairing of the stair of the suit building as prayed for, permission may be granted to the plaintiffs to undertake the necessary repair of the suit building by observing relevant municipal rules, if and without prejudice to the rights. Accordingly, petition is such and such, praying for order of repair of the suit building on consent of defendants, without prejudice, rights and concerned parties, plaintiffs are given liberty to repair, which are essential for occupying the premises. Millard, this is Millard 2nd of January 2024. Now, Millard, on the same day, writ petition was disposed of. Same day. Millard, looking at this order, Millard's coordinate bench, Millard had directed KMC to take steps there. Now, Millard, coming back in contempt, this scope was enlarged. Millard, my property, Millard, my tenanted portion, Millard, I am running business there. There are 54 shops which are being run. Now, Millard, I am only what I am praying for. Millard, I am praying for Millard so that I am not being non-suited. I am not being Millard this. Then Millard, may I put the question to myself? Millard, the suit will become, it will be rendered infructuous. What I am fighting for there? And Millard, this suit is a 2022. Writ petition is a year and a half later than that. Millard, I am only seeking, Millard, I should not be outstated from the property in the garb of this demolition. This is in continuation of this writ petition. Millard, only one judgment in 1992 of Millard single bench of this honorable court. Millard, where Millard similar circumstances Millard took place. It's 1992, 1 Calcutta Law Journal 389. Now kindly comes to Millard paragraph 9. Paragraph 9. Page 5. Millard copy paste Millard incident. Page 5, paragraph 9. Upon perusal of all the materials on record and considering the facts of the case in depth and in details and looking at the provisions of law as discussed above, this court is of view that in the instant case the writ petition has practically practiced fraud upon this court. It is found by this court that the petitioner has deliberately suppressed the notice and proceeding before this court, and there is no effective service upon the private respondents before the actual orders were made affecting the rights of a tenant. While the writ petitioner admittedly filed a civil suit for eviction of the respondent tenant, the petitioner has tried to make a shortcut way to achieve this object. And then Millard kindly comes to 10. This court has considered all the affidavits filed by the respective parties and looking at the materials on record, the conscience of the court is shocked that the writ petitioner has tried to collude and conspire with the corporation authorities in order to evict a tenant, but by not going to the civil court, but by coming to writ court and to achieve the object by making a frivolous and misconceived assertion that the tenanted portion of the property should be demolished. This court specifically finds that no notice of the proceeding was either served by the writ petitioner or by the municipal corporation authorities upon the private respondents at any relevant and material point of time. The Millard kindly comes to Millard, the portion Millard, paragraph 12. Now, Millard kindly read Millard paragraph 11 once. This court is aware of the provision of section 18 and 18A of the West Bengal Premises Tenancy Act. Thereof envisages intel as to how a tenant is entitled to restoration and compensation. Where the landlord obtains delivery of possession of the any premises from the tenant in pursuance of a decree and the building or rebuilding of any or additions and alteration are not commenced, or the premises are not occupied by the landlord or any persons or whose benefit the premises are held, as the case may be, within 6 months from the date of vacation of the premises by such tenant, or the premises having been so occupied by the landlord or any persons for whose benefit the premises are held. Millard, then Millard, it goes on. Millard kindly comes to Millard, from down the Millard bottom, the starting 5 lines, Millard, leaving 5 lines. The writ court is essentially, the writ court has Millard from the writ court. The writ court is essentially a court of equity. It grants relief to persons who come with clean hands and obtain equitable reliefs by obtaining powerful writ of the superior court in the manner as provided under the Constitution of India. If the court who has issued the writ finds that there has been an abuse of the process of law, the writ court should not feel hesitant to restore the possession of the property and direct the parties to get status quo ante before passing the impugned order. The present petitioner tenant was admittedly in possession of a portion of the premises. This court is convinced that the writ petitioner obtained collusive support from the corporation authorities and under the orders of the court, there is demolition of the tenanted portion and occupation of the respondent tenant by the corporation authorities and with the help of the police at the instant of the writ petitioner. There is no fault on the part of the respondent tenant. This court has considered all the aspects of the matter and finds sufficient merit in the contention of the respondent tenant to restore the tenanted portion caused status quo ante. Now, in my case, Millard, 411, in my case, Millard, 411 is stayed. It is stayed.
Yes.
Petition means to act.
Action under the supervision of the Honorable High Court. There may be, my lord, the scope of the ambit of the contempt application may be expanded.
Sir, my lord, one division means judgment, my lord.
They're not required.
When and where to move? My lord, depending upon the judgment passed by the Honorable Supreme Court. Now, my lord, they come before your lordship. They, my lord, space 61 shows private respondent appeared when the initial order was passed. We being the corporation actually facing the court. And thereafter, one by one, order has been passed under the direction of the Honorable Court. Your lordship, with the deepest humility, your lordship actually in a that is a subsequent way, my lord, the same strength. They should actually approach before the higher forum to challenging that order. Now they come before your grand, they have a good case. Deepest humility, my lord, they have a good case to argue before your lordship. But the thing remains when and where to move. My lord, the contempt, we are facing a contempt application, and day by day we are actually submitting one after another report and demolishing the building. Huge pain we are taking.
Yes.
Now they are coming before your lordship for passing an order to stay that order passed by the Honorable.
This has already been stayed.
How can it be? That is the only.
The notice is already stayed.
I will be very happy if your lordship actually stayed the order.
All right.
I am facing that pain.
Take down. The applicant has preferred the present application being GA number 01 of 2025 in a disposed of writ petition being writ petition number 1872 of 2020. Full stop. The applicant is seeking a direction against the respondent number 1 to 3 to restrain them from evicting / dispossessing them from the scheduled premises without following the due process of law. Full stop. Perusal of the record reveals that writ petition number 1872 of 2023 has already been disposed of by order dated 2/1/2024. Full stop. Once the matter has already been disposed of, either a review application or an application for modification of the order can be entertained. Full stop. No other application, as in the present one, is maintainable in a disposed of writ petition. Full stop. If the applicant is aggrieved by the order dated 2/1/2024 in writ petition number 1872 of 2023, either it needs to be challenged or he can file a review of the said order. Full stop. In view thereof, the present application is not maintainable and the same is dismissed. Next.
Item number 4.
For the petitioner lordship, in this matter, we have contacted to the petitioner thoroughly, but we are not getting any information that he wants to withdraw the matter. Since he is not doing anything, kindly make it go out of list because we do not have any other
Out of
options
list. I
left.
dismiss it. Why should I keep it burdened unnecessarily?
Because he's
Current
not
counsel for the
contacted.
petitioner states that she is unable to procure any instruction from the client. She doesn't even know if the client is interested in pursuing the present writ petition or not. She is unable to procure any instruction. Full stop. It is put to her that whether she wants to represent the client in the present writ petition. She states that since she is not receiving any instruction, she wishes to withdraw from the present writ petition. Full stop. In view of the same, the present writ petition is dismissed in default since there is no instruction or appearance on behalf of the petitioner in the present writ petition.
Item number 5.
I'm for the petitioner. My lord, in this, an interim order was passed on 8th of October. My lord, if your lordship is pleased to come, your lordship has a copy of that order. 8th October 2024. The first order in the writ.
Oh, yes, I do.
But kindly come to the second page, well, at the last paragraph. Now, this report was not filed, then kindly come to the next order, my lord, on 19th of March 2025.
Yes. Yes.
Again, my lord, the corporation was given opportunity to file affidavit, the report. At least, my lord, we have not been favored with any copy of any report.
Mr. Ghosh is appearing. I am for the state.
তুমি কেন কথা বলছো?
স্যার জিজ্ঞেস করলেন।
Where's Mr. Ghosh?
কোথায়?
My lord, actually, one contempt is going on. Mr. Ghosh is repenting. Passover will do that.
Next
Maybe.
week also.
But I
হ্যাঁ,
know
কাইন্ডলি
this
keep
is-
না না স্যার সুবিধা না আমাদের সুবিধা অর্ডার হবে দুটো চুল হতো না
order হবে না।
দেখবে তো
হ্যাঁ, দেখ।
চ্যালেঞ্জ ঠিক আছে and then kindly keep it and next
Mr.
week
Metro, he's not here, so shall we keep it?
next
Any day convenient to the court, I can give a fresh notice if required, my lord, also.
I will intimate
Next Thursday. Just intimate that he should file the report
Yes,
in
yes,
accordance with the order which has been passed. Just take down.
Then, my lord, yes, kindly give the direction to that effect.
This court-wide order dated 8th October 2024 had given a direction to the Calcutta Municipal Corporation to file a report. Full stop. Despite a follow-up direction on 19th March 2025, no report is placed on record.
Oh, শুক্রবার তো ছুটি।
One proxy counsel so-and-so appears and states that he seeks 2 weeks' time.
Not me, the Kolkata Municipal
If
Corporation.
anybody is proxy counsel for Kolkata Municipal, Miss,
My lord, can, instead of 17th, can it be on
I take only on Thursdays. I take the
24th, my lord, instead of 17th?
मैं पियाली सेनगुप्त.
just give your appearance as proxy counsel. What's the problem? You appear for Calcutta Municipal Corporation. States seeks 2 weeks more to file her report. Let the same be done. List on 24.
Lordship, I am obliged.
Number is
Seeks further time of 2 weeks to file her report. Let the same be done. List on 24. 24th will have.
item number 6. Item number 6.
Where's the petitioner? None for the petitioner, dismiss in default.
Item number 7.
Your Lordship, I am appearing on behalf of the petitioner. In the last occasion, it was related to serve copy upon the advocate of the KMC. I have served upon them. The case is, Your Lordship, I'm a resident of the locality, as well as have entered into an agreement with the private respondent of a shop room. The shop room and the entire building has been built legally without any sanctions plan. I had sent representation on 6th of October, that page number 19. However, it hasn't yet been considered. This is the entire building.
Yes,
without
Mr. Das.
My lord, this is in this matter, my lord, I have no written instruction, but over the telephone, my lord, we have already taken steps for demolition certain portion 2 times. I should actually file a composite report before your lordship on the next occasion, yours.
Mr. Das, who appears for the Calcutta Municipal Corporation, seeks and is granted 2 weeks' time to file a report. 2 weeks?
My lord,
2 weeks' time to file a report. Let the same be done. List on after 2 weeks.
my lord, get
2 weeks or 3 weeks? Action? You have started action or?
started action. We have started action 1 or 2 times.
Put 3 weeks, lift after 4 weeks.
3 weeks will be, my lord.
List after 4 weeks.
My lord, grateful.
Item number 7.
7.
Item number 8.
I'm for the Kolkata Municipal Corporation.
I'm for the private eventual respondent, Your Lordship. I'm led by Mr. Kollal Basu. Today is the date for filing report, Your Lordship.
Sir, I have my report. It appears that corporation has detected some unauthorized construction. If your lordship, if it so convinces to your lordship may direct the corporation authorities to give a hearing to the parties and pass a recent order within certain limited time, my lord.
Yes.
Yes, sir.
Is there any representation which you have made for unauthorized construction?
Lordship, one complaint was filed. Thereafter, no action was taken on behalf of.
They are saying that they have detected some unauthorized construction. Mr. Basu,
Yes.
they have detected some unauthorized construction.
Yes,
They say they can-
absolutely right. I cannot object for the sake of an objection. If it is reasonable and legal, I have to bow down,
So what I can do is I can ask them to grant a hearing to both the parties.
Yes.
And dispose of.
And the inspection report, I may be favored with the inspection report, so that I can take exception to that if anything is wrong.
I am extremely grateful. And since my lord, no affidavit has been called for, all allegations my lord made, my lord did. I am extremely grateful. Okay, the file goes.
This is your complaint, page 62. Just see, this is the complaint which you have filed.
Page 62.
Yes, madam, please.
Appearance.
Page 62.
এই কমপ্লেন্টই ফাইল করেছিল বলে দে হ্যাঁ
This is the complaint.
There are 6 violations that have been detected, madam.
And it has been categorically explained in my complaint.
এই রিপোর্টটা করে
Report.
অবলোক কোথায়
They have already initiated action. What more do you want?
They have initiated the actions on a date because this was unclear to us till date. Because
Yes, but due process of law has to be followed. Initiation of action doesn't mean they will demolish it immediately. They'll give a hearing to the party concerned.
entire construction in
Whatever it is, due process of law has to be followed, sir. So I can dispose of in terms of the inspection report. They'll follow with the procedure.
hearing before the SOB previous may be allowed.
Hearing will be given to the concerned
and all
person who's
points are
carrying
le-
out the unauthorized construction. Your client is the one who's
my client I'm responding number respondent number 6 and 7 right
learned counsel for the, just take down.
report
Where's the order file? Order file?
I don't know.
एक order नहीं है. Take. The petitioner,
Copy of the report. Sir.
give a copy of the report.
আমাদের
Just read that.
yes
The petitioner has preferred the present petition alleging unauthorized construction being carried out by private respondent number 2 and 3 in property number 17/1 Pyare Mohan Sud Lane, Ward 016 BR2. Full stop. It is the contention of the counsel for the petitioner that the respondent is carrying out unauthorized construction in contravention of the sanctioned plan. Full stop. Learned counsel for the respondent corporation has conducted an inspection and filed a report dated 9/4/2025 by the EE building, wherein it has been stated that some deviation is there from the sanction plan, and the private respondent number 2 and 3 has done some unauthorized construction. Full stop. From the report, it is further gathered that the completion plan was sanctioned. The completion plan was sanctioned on 17/8/2018. And the current deviation is in violation of Rule 62, 70, 78, 133, and 134 of the KMC Building Rule 2009. Full stop. Learned counsel for the respondent corporation states that further proceedings will be drawn against the private respondent to put the matter to a logical end, full stop. I can dispose it of. Learned counsel for the petitioner states that learned counsel for the petitioner has seen the copy of the report and is satisfied that the corporation is taking action in accordance with law and shall complete the process within a period of how much time? 8 weeks?
12 weeks you are saying. Well, one difficulty on our part, my lord, I had a talk with my officer. He said the file on which the report was prepared on earlier occasions and also my lord physical inspection today. But they said the file is not readily available. I have instructed them to reconstruct the file on the basis of the report which has been prepared. Therefore, it may some time to reconstruct. If it is not available, you'll also grant me 12 weeks time.
Shall take within a period of 12 weeks. Full stop.
But I may have the liberty, my lord, to take exception to the report and all points of that.
Needless to state,
in a hearing, the notice
the private respondent
6 and 7.
6 and 7 shall be given an opportunity of hearing in accordance with law before any action is taken.
In the process of consideration and hearing and disposal of the demolition case.
My lord, kindly, my lord, allow me to take exception of this.
Not in this, my lord, because on the basis of that report, a notice, my lord, under the act, the prescribed, my lord, the provisions, my lord, notice to be issued, giving the details of the unauthorized construction as detected. Then parties would be liberty to take, my lord, to show cause or exception, whatever it may be. Then matter will be placed to the competent officer, my lord, special officer building for hearing. Then they may take whatever they intend.
Very important utterance, my lord, on the part of the KMC. That
so what I can then, Mr. Ghosh, in that case, let me just dispose of the representation with whatever.
Well, whatever the representation he may say, on the basis of that, my lord, I will come to this conclusion.
Yes, absolutely.
Now, after this conclusion, my lord, matter whether the
obviously you'll issue a show cause notice. They will respond to the show cause notice. Then only a final order will be passed. Obviously, due process of law has to be followed.
That is what I'm submitting because this has been made ready.
Yes.
And on the basis of that, my lord, notice to be issued.
Correct.
And they, my lord, they may make a response to that notice.
That goes without
saying. The hearing took place. Hearing will take place.
That goes without saying.
Yes, kindly clarify, my lord, that what is.
Clarification, that is the process. 12 weeks to
He has said 12 weeks.
I'll just dispose of the representation. You have the liberty to carry on.
Well, I consider, I subject to lordship, my lord, what my lord say, my lord. After the objection, the representative consider, I will come to this primarily this finding, then matter to be placed before the competent officer.
Just strike down that
report.
No, just ऊपर क्या लिखवा है first line से पढ़ो. Copy of the report. What are the learned counsel for the petitioner? The present writ petition has been preferred, alleging unauthorized change kar do order. The present writ petition has been preferred, alleging unauthorized construction on premises on holding number 17/1, Pyare Mohan Sur Lane, ward number 016, BR2. Full stop. It is the learned petitioner alleges that unauthorized construction is being carried by respond number
6
respond number 6.
No, we are the flat owners, promoter 1 and 2. But I am the flat owner.
Their unauthorized construction is being carried out by respond number 2 and 3 on the above said property.
But a developer is not a party who has really constructed.
That's why I'm not let the representation be decided. Full stop. Learned counsel for the respondent, corporation, Mr. Ghosh submits that they are ready and willing. उससे पहले एक line लिख दो. The petitioner has preferred a representation dated. What is the date of your representation?
862.
29/5/2024. Full stop. Though he has not heard anything from the department regarding the said representation. The department has not decided his representation. Full stop. Mr. Ghosh, learned counsel for Calcutta Municipal Corporation, submits that they are ready and willing to decide petitioner's representation dated 29/5/2024. Full stop. Learned counsel for the petitioner states that he shall be satisfied if his representation is decided within a time-bound manner. Full stop. In view of the said statement, this court directs respondent Calcutta Municipal Corporation to decide petitioner's representation dated 29/5/2024 within a period of 12 weeks.
That is not required because after the disposal of this
Within a
representation, then I will initiate the proceeding.
Within a period of 6 weeks? Within a period of 6 weeks from the date of communication of this order, after granting an opportunity of personal hearing to the petitioner as well as the private respondent or any other interested party by way of a speaking order. With the above direction, the presented petition is disposed
And
of.
my lord, since your lordship has not called for any affidavits, all allegations. my lord.
All allegations,
Because you
no
know,
affidavit has been
asked
called for,
details
वो line
to be
आता है ना, no affidavit.
Deeply obliged.
The report to become.
Item number 9,
I disposed of that.
Yes, my lord, I.
Your arguments are very to the point.
Yes.
Yes. We'll pass it over. Let him come.
I have no difficulty.
We'll hear it. You are prepared, Mr. Mukherjee? You are prepared?
Yes, madam.
Good. George sir, are you prepared or not? I'm prepared.
Let Mr. Sen come. We'll hear it.
Pass over. After the entire list.
No, we'll take it up. We'll take it up, at 12:10 we'll take it up.
And very
You
good.
tell Mr. Shakir Sen, we'll take it up.
item number 10,
Lord Lordship, I beg to appear on behalf of the petitioner. My lord, this is also unauthorized construction. 61/H/25 is Mohesh Parikh Lane. It is a Thika property. My lord, in case of Thika lordship, any construction is required to be made with the approval of the Thika tenant, Thika controller. And thereafter, my lord, the permission sanction plan from the Kolkata Municipal Corporation. In the instant case, nothing has taken and doing construction merely. And in spite of our reminder to the local authority, my lord, they are yet to take any action. My lord, innocuous prayer, my lord, let there be a direction, my lord.
We have already inspected.
Just give it.
I've given. The entire building appears to us to be unauthorized. It's a 3-story building. That my officer informs me.
What
We
is
have given 401. Then we have given police intimation and demolition proceeding. has
what is
been
more, my lord?
indicated.
On indulgence,
And area of unauthorized construction, I have indicated that also.
about 3,000 square feet, more than 3,000 square feet. My lord, what happened? Page 16, my prayer. My lord, in the instant prayer, my lord, we are making this prayer on drawing the attention of this honorable court. 401A provision in the Kolkata Municipal Corporation is there. In the event of this type of reckless unauthorized construction, KMC can take penal action against the person responsible. Our humble submission, let that direction be given, my lord, to the Kolkata Municipal Corporation Authority. My lord, in the event of it is collapsed, my lord, since is this property, my lord, I am a tenant, Thika tenant, and Bharatias are doing all this mischief, my lord, I shall remain responsible. Though I have no responsibility, they are doing it at their own, my lord, the muscle power. So our humble submission, page 16.
Yes.
I'm waiting for the respondent number 11. Milord, I'm one of the tenant, admittedly a tenant. Milord, I have no relation of making construction. I have an agreement with some of the developers who has named as private respondent number 9.
All right.
Now,
You
Milord,
go before the authority concerned, they will see that.
Yes, Milord, my only humble prayer is, Milord, law is settled, Milord. In case of a tenancy, Milord, my tenancy right is to be protected. Before demolition, the authorities will ensure that measurements are there. If a building is reconstructed, I will
No,
be
my lord,
reinstated.
in the event of new construction is made over the said plot of land, rehabilitation is to be given. It means, my lord, not that they are permitted to do unauthorized
I
construction
have not done anything.
without taking permission from the Thika
But there is no
controller
notice even served upon me.
as well as authority.
I've been made a party, but no notice has been served come from the KMC also that I have done it.
And kindly visualize 3,500 square feet construction. And my lord, the corporation is, my lord, entrusted, my lord, to look after building regulation. It is their mandatory function, my lord, that being the situation.
All right, learned counsel, the petition has preferred the present petition has been preferred, alleging illegal and unauthorized construction at premises number 61/H/25, Mahesh Barik Lane, Calcutta. Full stop. Petitioner states that large scale illegal and unauthorized construction has come up on behest of the private respondents over the said plot of land. Full stop. Over the above mentioned plot of land. Full stop. Learned counsel for the respondent. Which corporation is this?
The Kolkata
Calcutta Municipal Corporation has handed over a copy of the report wherein the corporation has already issued stop work notice under section 401 of the KMC Act on the alleged perpetrators of the unauthorized construction on 7/9/2024. They have sent the copy of the same to the local police station. Demolition proceedings has been initiated under section 400 of the KMC Act 1980. Full stop. Even the area of unauthorized construction has been measured. Full stop. A copy of the said report is handed over to the counsel for the petition, who states that he will be satisfied if the said proceedings is carried out in accordance with law within a time-bound manner. Full stop. Right, Mr.
Yes, sir.
Learned counsel for the respondent corporation states that they shall carry out the proceedings in accordance with law within a period of
around 8 weeks or 12 weeks.
12 weeks.
Because
The period of 12 weeks.
I have indicated 400. I do not know. I can proceed under 401 where there is a concept of hearing. I can also proceed under subsection
Whatever,
400. There is no concept of hearing over there.
I'm not commenting on.
That your lordship gives that's my prerogative under which provision I go.
Absolute. Within a period of 12 weeks from the date of communication of this order. In view of the said statement, nothing survives in the present.
Only one
My lord, positively, my lord, within 12 weeks.
Only one
And
thing,
one
my
more
lord,
in
can
the
be record. Since, my lord, I find, my lord, the notice has not been served upon me, my lord, I am a tenant. My lord, I have no right to say that kindly measure my tenancy and protect my tenancy. My lord, to that extent, kindly observes that tenants have a right to, my lord, to protect its tenancy by causing a measurement.
I'm only looking at the unauthorized construction, sir. You go wherever you have to go. You know where to go.
If I
My lord,
proceed under subsection 8, there is no concept of.
my lord, the
There
respondent
was
number,
no concept of hearing. I am not going on to that.
Sir, you know where to go.
my lord, respondent number 7 is foolish. My lord, direct police authority to ensure not to do further construction. My lord,
To that they will follow up.
no, my lord, that direction, unless that direction is issued, KMC is also sometime embarrassed, my lord. The police is not cooperating and all these things. They used to take this plea before the honorable court, my lord.
Needless to state that
Lordship.
the local police station shall act in accordance with the stop work notice, which has been intimated to them on 7/9/2024.
And there's an affidavit of service may kindly be kept in record.
Affidavit of service is taken on record. The present writ petition is disposed of in terms of the above direction. Copy of the report is kept on record.
Deploy.
Item number 11,
For 11, Mr. Saurabh Guchait is appearing for the petitioner. I have been instructed to take an adjournment for a week, Your Lordship.
Yeah.
Mr. Saurabh Guchait is appearing for the petitioner. He has instructed me to take an adjournment for a week, Your Lordship.
Proxy counsel so and so appears and states that the main arguing counsel is indisposed. He requests for a short adjournment. Let this matter be listed next week.
item number 12,
My lord, I am appearing for the respondent number 9 in this matter.
For the petition.
Unfortunately, Lordship,
this
happens to be an extortion litigation.
My
Under the garb of this,
petition may submit. I know, I have to cross the hurdle of the locus. But I have made a representation to the Calcutta Corporation alleging illegal construction. The same premises, another public interest was filed. Please, Honorable Court, the petition bench of the Honorable already directed the corporation to take steps. But no steps has been taken. And I have further made representation.
So if you know that on the same property there's a direction which has been passed, then why have you filed this?
No, but I have, after filing this, I have to
Withdraw it.
But since there is already an order, kindly record that order also.
I'll record more if you want me to. You're passing by, walking there, something falls, please. Let it stay there, sir. Let it stay there. This is extortion and nothing else. Do not allow this court. I'll put exemplary cost on you. I know what kind of petition it is.
my lord, 50 lakhs was demanded. We lodged a complaint.
Don't tell me I've seen it. You want observations? I can give observations. And I'm telling you, sir, I know how this petition has been filed. And tell your client not to file these kind of petitions, especially before this court. I'm being lenient this time. You're walking by, debris falls, you get hurt, you file petition.
Kindly allow me to.
Learned counsel, the petitioner seeks to withdraw the presented petition. The same is dismissed as withdrawn. Tell him not to file these petitions. And if keep the petitioner's name somewhere. Put a record of this petition thing. It reflects poorly even on the lawyer.
item number 13,
I am for the petition, Your Lordship. My lord, it's a second round litigation, my lord, against the praying for demolition of unauthorized construction. Your Lordship, kindly come to the page 12. The order passed by the corporation, page 12, Your Lordship. Area of total unauthorized construction 415 square meter. And then Your Lordship, kindly come to the next page. The demolition should be done within 1 month from this order. The order passed on 9th May 2024. Almost, my lord, 11 months already crossed, my lord. No, they have not yet demolished that unauthorized construction. And this is second round litigation, my lord. The first page, kindly come to the page 9. This is the first order. This is the first read. After passing this order, they have considered my petition and then passed the order of demolition. And the ordered person, may I read that ordered person, Your Lordship?
Yes.
Now, therefore, PRS may be hereby required notice under section 401 of the Kolkata Municipal Corporation Act 1980 to demolish the unauthorized construction beyond the section plan of the building within the 30 days from the date of service of this letter, failing which Kolkata Municipal Corporation will proceed for demolition of PR's own risk of said unauthorized building and the expenses of such demolition shall be recoverable under subsection 7 of the section 400 of Calcutta Municipal Corporation in 1980. And this sketch will be part of the and parcel of the order. So, my lord, the order is very clear. Let them demolish, my lord.
Yes.
Already 11 months already passed.
Receive the instruction after receiving this copy of the petition. We have instructed the officer concerned to give me the instructions about this, whether any appeal has been filed or not, or what steps you have taken. We have not some time maybe given so that I can.
Already, my lord, 11 months already passed, my lord. If there is any appeal, my lord, they ought to have.
Madam,
Yes.
you have made your submission.
Yes, my lord, I have.
Take down.
But my lord, order passed on 9th May 2024, and the today is the April.
Can I
Almost the 11 month already passed.
Can I pass order?
My lord.
Or you'll dictate that?
Oh, no.
Take down. The petition in the present writ petition is aggrieved by the inaction on part of the respondent corporation in not concluding the proceeding initiated by them by order dated 9/5/2024. Full stop. This is the second round of litigation. Full stop. In the first round of litigation, this court by order dated 31/8/2023 in WPO number 1542 of 2023 had directed the petitioner to prefer an objection before the respondent corporation, highlighting the deviation made by the private respondents who were carrying out unauthorized construction at premises number B14/H/4 Bindu Basni Street, Ward number 78, Borough number 9. Full stop. In compliance of the said order, the respondent passed the order dated 9/5/2024 for demolition. Full stop. The said order had given the said order had given 30 days to the PR to remove the unauthorized construction, and failing which the Calcutta Municipal Corporation will proceed with the demolition action. Full stop. Learned counsel of the petitioner states that despite the said order and considerable delay, the respondent corporation has failed to act on its own order dated 9/5/2024. Full stop. Learned counsel for the respondent corporation seeks and is granted 2 weeks time to file a report indicating the follow-up steps taken after the issuance of the demolition notice dated 9/5/2024. Full stop. Let this matter be listed after 2 weeks. Affidavit of service is taken on record. Or you tell me when will you conclude the proceeding, I can dispose of.
Yes, I can take instruction if you.
When will you conclude the proceeding, I can dispose of.
We have concluded the proceedings, but ultimately,
Conclude the proceeding, take further action, demolish the building.
Since the private respondent, whether he has filed any appeal or that instruction, I have not. If there is any order, maybe there is a provisions for appeal. They may file an appeal. If they file appeal, then we are.
Why didn't you take instructions, sir?
We have received the matter on few days before. I cannot get it.
All right, list after 2 weeks. Next. After 2 weeks.
Item number 14.
For the petitioner, there are certain facts which has not been included. Kindly give me some time so that I will file with affidavit.
What supplementary affidavit, madam? Why the petitioner is bereft? This is that Bake Saab restaurant. What do you want? What do you want to put? What is not there?
I have also prepared an appeal before the pollution appellate authority of the pollution control boards regarding that they have obtained some certificates. Consent to operate and consent to, these are all the things which is not included in my writ petition. Kindly give me some time so that I can.
No, I will not allow you to file a supplementary affidavit like this, madam. You should come clean to the court. If you have not come clean, you withdraw this, file a fresh writ petition. That liberty I can give you, but I will not allow you to continue with this.
Then your lordship.
Learned counsel of the petitioner seeks to withdraw the present writ petition with liberty to file a fresh with better particulars, bringing on record material facts which have not been placed on record with the present writ petition. Full stop. The said liberty is granted. The present writ petition is dismissed as withdrawn. Here.
Item number 15.
There is a lot of certain developments have developed in this matter after filing of this writ petition, Your Lordship.
What development?
They were called for hearing and order was communicated to the Your Lordship. That is to be included in this by way of supplementary affidavit, Your Lordship.
Order has already been passed. There is no supplementary affidavit. You challenge the order.
Your Lordship, that has been taken place after filing this writ petition, Your
Yes,
Lordship.
so you challenge.
Your Lordship.
Madam, then you challenge that order by which you are aggrieved.
Lordship. No, that was on the previous second order application. They have served all that documents have to be placed on record, Your Lordship. You know, I think this is a liberty to file that.
No supplementary affidavit. You guys file petitions without material particulars. You all.
They have called us for hearing, Your Lordship.
You have got the hearing before the Municipal Valuation Committee.
Yes, Your Lordship. The notice was served on us after filing this writ petition.
All right. So you carry your proceedings there. And if you are aggrieved by any order passed by the Municipal Valuation Tribunal, you come back.
Your Lordship, let us come with this. Let us play by your.
You have challenged it as it is. This is not maintainable here. This is against the assessor and collector.
Yes, Your Lordship.
Not maintainable. You withdraw this, madam.
Your Lordship, then I have to take instruction for withdrawal because I'm not the advocate on record on this matter.
Seek next week.
My Lord, I'm for the bank.
Let it
Learned.
be there on 17th. My Lord, pardon my impertinence.
No problem. When you're not there on 17th.
Probably I'll not be there.
Your Lordship, and then next monthly list, Your Lordship.
No, why?
No.
24th.
24th. Let this learned counsel of the petitioner states that she will take instruction from the client if the client still wishes to pursue the present, if the client wishes to pursue the present writ petition, since they have already approached the Municipal Valuation Tribunal and the hearing has been fixed. Where is the hearing fixed?
Hearing was fixed, Your Lordship, and the order has been communicated to us, Your Lordship.
Has approached the Municipal Valuation Tribunal.
That's why.
Let this matter be listed. Let this matter be listed on 24th. I will not allow that, madam.
As Your Lordship.
Great.
Item number 16.
Number 16, Your Lordship. Your Lordship, in item number 16, I'm being led by the particular senior advocate. Your Lordship is on his legs before the Honorable Chief Justice. I will kindly give us the short password of it.
Lord, what has happened here
Yes,
is
Mr.
they
Khan.
have challenged, Lord, vires of a provision of the Kolkata Municipal Corporation Act. This amendment has come into effect with retrospective effect. Now, Lord, the learned advocate general needs to be served, Lord, with a copy of this petition. He has been. Very well.
I'm
Very.
assisting him, Lord. Today he is not Yesterday he is to Delhi. Today he is supposed to come back.
Your Lordship, Mr. Majumdar is.
Yes, Mr. President.
Fine.
এর যে অ্যাডমিটেড ডিউস আছে সেটা দিতে রাজি আছিস তোরা 96 Lordship will find that in this writ petition we are challenging an amendment, a validation amendment made to the KMC Kolkata Municipal Corporation Act by basically nullifying a judgment, inter partes judgment between the petitioner and KMC, and the matter traveled to the Supreme Court not once, twice. The whole, if your Lordship kindly takes, we have prepared a list of dates because this matter has a checkered history. Kindly get the list of dates for the Honorable Court. Hearing that. The Lordship will find a writ petition was filed by the petitioner in 2011, praying for my lord this declaring the second proviso to section 179 2D of the KMC Act to be ultra vires.
Yes.
Then also my lord, a writ of certiorari was also prayed for regarding assessment orders, for quashing the assessment orders for certain tax periods. Your Lordship will find that in the prayer portion. And on February 22, 2012, the Honorable Single Judge directed the petitioner to deposit 1 crore 28 lakhs and odd with KMC within March 14, 2012 and 35 lakhs by March 26, 2012. The KMC was restrained from taking coercive steps against the petitioner till March 27, 2012. My lord, the petitioner deposited that 1 crore 28 lakhs on March 13, 2012. On April 11, 2012, the Honorable DB passed an order setting aside the direction to pay further sum of 35 lakhs. The matter went back to the Honorable Single Judge. Well, Your Lordship, we have given all the relevant annexures and the pages. Passed an order in WP number 1201 of 2011 that the petitioner had unconditionally given up the challenge to the vires of second proviso to 179 2D during the hearing of the writ petition being number so and so. So, my lord, the petitioner then again preferred an intra-court, my lord, appeal, and this judgment, my lord, is the key factor. My lord, may I take your Lordship to page 119? My lord, kindly take page 119.
Yes.
I take your Lordship to the operative part of the order. Well, kindly take from page
119. Huh?
119. Kindly take, my lord, page, internal page
Yes.
8 of the order. Internal page 9 of the order. 8 of the order. The power conferred on the municipal commissioner. My lord has got that.
Yes.
The power conferred on the municipal commissioner to revise the annual valuation of land or building under section 179(2). Second proviso was indeed unlimited in the point of time and very wide in amplitude. Any piece of legislation it should be, my lord, where unguided or uncanalized power is given to an authority to that extent is invalid. Therefore, the power conferred on the commission, in my opinion, is indeed so unlimited that it falls foul of Article 14 of the Constitution. However, in the Supreme Court cases discussed by me above, similar powers were conferred on the authority in case of New Delhi Municipal Committee versus LIC. Similar powers conferred on the Municipal Committee under the Punjab Municipal Act to amend the assessment list. In all these matters, including the municipal matter, the Supreme Court did not declare the provisions as ultra vires, but tried to read down the rigors of the provision by implying the words into the offending provision so as to make a provision reasonable. It implied words within reasonable time after the phrase at any time to make the section workable. We adopt the same procedure. The commissioner can only have the power to revise valuation within a reasonable period of time.
In the case of Santosh Kumar Shivgonda Patil versus Balasaheb Tukaram Chevale, reported in 2009 9 SCC 352, the Supreme Court computed reasonable time in Subject Act to be 3 years. In Section 573 of the Corporation Act, the corporation has the power to recover any sum by initiating a proceeding within 3 years from the date such sum became due and payable. Therefore, on a proper interpretation of the proviso and upon reading it down to save it from unconstitutionality, the period for which a valuation of property can be raised must not be more than 3 years before the date of revising the revising order. In those circumstances, this appeal is partly allowed by directing the respondent corporation to make fresh assessment in relation to the period covered by prayer B of the writ petition on the basis of the observations made in this judgment within 8 weeks of communication of this order, and to raise final bills on the appellant or petitioner within a further period of 1 week, and realize the same as soon as possible, not later than 4 months from the date of service of this order. So, my lord, the period was defined and defined to be 3 years from the date of revising the order. Now, my lord, kindly take, my lord, this judgment was carried to the Honorable Supreme Court. Kindly take page 132 of the, my lord, the petition. My lord,
Page
132. I'm sorry, my lord, 132. But this is an order dated 18 January 2019. My lord, the specially petition was dismissed. My lord has got that?
Yes.
Now, my lord, then, my lord, the KMC moved a review petition before the Honorable Division Bench. Your Lordship will find the order at page 145. It's a very short order. If your Lordship's permit, then, my lord, may I just read out the order. The operative part of the judgment and order.
Almost the same, revision of the same.
Yes. And the
Just observation.
review petition was dismissed. Then, my lord, once again, my lord, an SLP was preferred against this dismissal of review petition. Well, ordinarily under Order 47, Rule 7, it does not lie. That is why, my lord, the honorable judges of the Honorable Supreme Court expressed doubt as to whether the review would lie at all. But again, on merit also, my lord, the Honorable Supreme Court held that this petition
Page
should.
153.
Yes, I'm so grateful to your Lordship. I'm so grateful. 153. But this is all happening on 3rd of May 2024. Your Lordship will find this review petition was, this SLP was dismissed.
Yes.
Now, my lord, kindly now take a relevant date. In the meantime, in KMC Municipal, an amendment bill was initiated to the KMC Act. My lord, the bill of copy of the bill now. It has not been annexed. I brought the bill. Don't have. Very well, my lord. I'm so sorry, my lord. My lord, an amendment act has been annexed, which your Lordship will find at page 161. My lord.
So what, the period is enhanced from 3 to 6 years?
Yes, yes.
This is what you're telling?
Yes. Not only that, my lord, what they say, kindly take, my lord, DII, where it had already been made or revised beyond such period, the same, including realization of property tax on the base thereof, shall be deemed to be valid. So, my lord, this particular amendment seeks to nullify an inter partes judgment expressly because, my lord, its start begins with this non-obstante clause that notwithstanding anything contained in this act or any judgment or decree. And my lord, kindly take the date of this act, the date of commencement of this act. This act were the date of commencement was 31st May 2023, subject to correction by Mr. Kaur. So when my lord, the review petition was pending, then SLP also preferred against the dismissal of review petition. In the meantime, my lord, they brought about this amendment and seeking to nullify the judgment rendered by the Honorable Division Bench, which has, my lord, been affirmed by the Honorable Supreme Court not once but twice. And now on the basis of the amendment, my lord, they raise the issue a letter. That letter is also subject matter of challenge when we have also challenged the Amendment Act. Kindly take, my lord, the letter at page 158.
It means that D Roman 2 would mean that the period is not defined.
No. It can be any period, my lord.
It can go beyond
anything, 20 years, 30 years, whatever it may be.
wherever the revision.
Wherever the revision would lie. My lord, this is, my lord, abhorrent to the scheme of, my lord, this separation of power between judiciary and the, my lord, the legislature.
That you have to show the constitution.
My lord, I'll tell you, Lord, I'll take your lordship directly to two judgments rendered by the Honorable Supreme Court. Kindly take once, first, State of Kerala Tadam.
Because even the constitution, what 243W or so, that would also give some powers to the municipal corporation to frame regulations.
May I just, Lord, cut short this matter? Lord, one aspect of the matter is revalidation of the act. That's one issue. The other is what the division bench permitted from 1996 onwards. Lord, that also they have not paid. So, Lord, in so far as this revalidation part is concerned, may I file a very short affidavit? Lord, because, Lord, the purpose, object, etc., that has to be brought on record, which is not on record.
Absolutely.
So, Lord, I just use a short affidavit on that. And Lord, in so far as the dues of 1996 is concerned, it is running to about 11 crores. Your Lordship kindly sees the demand, which is at page 158.
But when we asked for refund, then this letter was issued.
The question,
We asked for refund on the basis of the judgment rendered by the Honorable Division Bench.
And who are you basically? What is this? It's a charitable.
so this is, I don't know, Lord, they are the petitioner. I appear, Lord,
It's a
for the
charitable
Kolkata
trust.
Municipal Corporation.
But this is a charitable society.
No, the
But
Times of India
It
group.
was that time, it is, my lord, at one point. The Times of India group. Is it still associated? It is still associated with the Times of India group.
They are the Times of India group.
But it is a charitable society. It is not, my lord, the business operation.
Lord, whatever it is, Lord, there
My
is
lord,
a property, prime property in Calcutta. We are only concerned about the valuation and the revaluation of the property. That's the issue. Its charitable organizations are not exempted from payment of
No, that
property
is not
tax.
even my case.
So therefore, Lord, I am saying, Lord, this is the issue with regard to revalidation. That, Lord, I'll file an affidavit. But Lord, whatever allowed by the division bench.
Well, let us see
and
whatever
affirmed by
was allowed by the division bench. Let us see what is allowed by the division bench.
This
If division,
can't
kindly
be
take my lord.
decided without your affidavit or without the affidavit of the state.
No, that fourth quarter 96 onwards, whatever is.
But
there,
they waited for
Kindly
the
must see
outcome,
the
Malad.
order
They
of the
waited.
division
Malad, may I just one thing, Malad? Kindly bear with me for 2 minutes, Malad.
Just 1 second. May I
Yes.
show the order of the division?
Yes.
Lord, please come to page 129.
Yes.
In those circumstances, this appeal is partly allowed by directing the respondent corporation to make a fresh assessment in relation to period covered by prayer B of the writ petition on the basis of the observations made in this judgment. With 8 weeks of communication of this order, raise final bills on the appellant petitioner within further period of 1 week. Please come to page 96. The prayer B is there.
Prayer we have quoted in my list of dates.
Very well. I mean, wherever it is. The assessment period,
Yes.
page 96. I'm sorry.
Yes.
Let kindly see the assessment periods are from fourth quarter 84-85 up to third quarter 1991, fourth quarter 1991 to third quarter 96-97, fourth quarter 96-97 to fourth quarter 99-2000 and all records in connection therewith. So, my lord, these are the periods for which, my lord, the revaluation was permitted by the division bench, and that has been reassessed.
Yes.
So, my lord, whatever the dues are with regard to the period which has been reassessed, my lord, that they have to pay, because, my lord, in any event that does not come within the scope of revalidation. That those issues are final between the parties.
Wait.
The period of revaluation prior to 96 is the issue before your lordship.
Madam, may I just take your lordship?
Yes.
I'm so sorry, madam.
Yes,
May I just take your lordship back to page 128? Mr. Kaur had read the last paragraph, but not the penultimate paragraph. The penultimate paragraph says, but it has to be read as a whole.
Yes, yes.
We adopt the same procedure. The commissioner can only have the power to revise valuation within a reasonable period of time. In the case of so-and-so versus so-and-so in 2009 9 SCC 352, the Supreme Court computed reasonable time in the subject act to be 3 years. In section 573 of the Kolkata Municipal Corporation Act, the corporation has the power to recover any sum by initiating a proceeding within 3 years from date. As such sum may become due and payable. Therefore, on a proper interpretation of the proviso and upon reading it down to save it from unconstitutionality, the period for which a valuation of property can be raised must not be more than 3 years before the date of revising the order. In those circumstances, this appeal is partly allowed by directing the respondent corporation to make a fresh assessment in relation to the period covered by prayer be on the basis of the observations made in the judgment. So it cannot stretch beyond 3 years under any circumstance. And they have failed before all the fora. And there is no assessment. Where is the assessment? I put the question to myself with all humility. I have not been favored with any assessment order.
If your lordship kindly comes to page 158, once again, the demand. Kindly, my lord, come to the second last paragraph. Therefore, the demand that emanates from the annual valuation so-and-so for so-and-so, 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 then with effect from fourth quarter 96-97 stand upheld as the same have been validated in terms of the amended section such and such, then as on date an amount of such and such. Lord, fourth quarter 96-97, in any event, Lord, is validated by reason of the order of the division bench. Because, Lord, the writ petition which was filed, the assessment was undertaken in 2000 with regard to 99-2000 was the last assessment year. So 96-97 to 99-2000, this period, Lord, was the 3-year period.
My lord, may I?
So that you are saying that the period what is 99?
96-97 to third quarter 96-97 to fourth quarter 99-2000, that comes within the period of 3 years. If we go by the division bench judgment.
My lord, I'm sorry, my lordship is noting down.
Yes.
My lord, will kindly come back to page 158.
Yes.
The judgment rendered by the Honorable Division Bench does not form the basis of the demand. The basis of the demand is the amendment made to the KMC Act. They exercise their power on the basis of the amendment so made. Kindly take, my lord, the second paragraph. The second paragraph. Therefore, first they quote the amendment. Then they say, therefore, the demands that emanate from the annual valuation of so-and-so, so-and-so for so-and-so, so-and-so stand upheld as the same have been validated in terms of amended section of 179(2)(d) of the KMC Act 1980. As on date, an amount of rupees, there is no basis, nothing. As on date, an amount of rupees 11 crores so-and-so, including interest. My lord, kindly take the interest part. This is so interesting. So, my lord, out of demand of 11 crore 24 lakhs, interest is 8 crore 22 lakhs, and penalty is 39 lakhs, is lying outstanding as property tax. you are requested to pay the outstanding as soon as possible, failing which the KMC will be constrained to take tax recovery steps as per law, where the division bench directed them to undertake the process afresh. They cannot rely on the assessments which were made prior to the, my lord, the judgment rendered by the Honorable Division Bench.
Lord, I can further, Lord, cut it down.
In this,
Interest and penalty can be kept pending for your lordship's consideration at the final stage. The balance, let them pay.
No, but Mr. Carr, if the assessment has been done without taking into consideration the order passed by the division bench, and in terms of the amendment which you have carried out, then there is a problem with this.
Lord, I tell your lordship, what the amendment says, it validates, Lord, insofar as the
period is
concerned. So, Lord, we are today going by the division bench's judgment, at least, Lord, from 96, 97 onwards.
The assessment valuation will not change.
Not change. So, Lord, 96, 97 to 2000, which is the relevant period for which the revaluation was under issue. Lord, at least for that, they are liable to pay. I am saying, Lord, forget about the interest, forget about the penalty, etc. That your lordship will decide ultimately. But, Lord, today, on the face of it, that the balance 3 crores is not they have to pay. They can't, Lord, sit on this property and not pay the tax.
There was an earlier direction also of some payment.
Yes, my lord, we paid 1 crore 28 lakhs pursuant to the direction given by the Honorable Single Judge.
Yes.
And additionally, 35 lakhs was required to be paid. We carried that order before the Honorable Division Bench. Honorable Division Bench was pleased to set aside that part of the order. And my lord, 35 lakhs we were not required to pay. So as on date, we had paid 1 crore 28 lakhs as back as in 2012.
Oh, that has been factored in here. In the calculation, that has been factored.
Well, everything has been factored in here, but they are to undertake a fresh process.
No, sir, but fresh process will take place, but some deposit has to be made.
My lord, kindly bear, 1 crore 20 lakhs has been paid, my lord.
1 crore.
My lord, kindly bear with me for 1 minute. My lord, I'm so sorry, my lord. Well, I don't want to interject the thought process, my lord. I'm sorry. So, my lord, kindly bear with me. Kindly take, my lord, for once. I take your lordship once again back to the review order. Review order is very important, which was passed by the Honorable Division Bench at page 145.
145. Huh?
Yes, my lord. I'm grateful, my lord. My lord, I take your lordship to the operative part. The operative part of the judgment and order dated 26 April 2018, of which review is sought, observes and directs the commissioners could only exercise the power to revise the valuation within a reasonable period of time, which is 3 years, following the case of Santosh Kumar Swanso, that is 2009 9 SCC, reading section 573 of the KMC Act, and to save it from being unconstitutional, this court held that the period for which valuation of the property could be revised could not be more than 3 years before the date of revision order. Now, I take your lordship once again back to the main judgment. I mean, the order passed by the Honorable Division Bench. 129. So, this was, my lord, the parameters were set. The authorities were required to act within the parameters so defined by the Honorable Division Bench. And the procedure was also laid down in page 129. Your lordship will find that is the penultimate paragraph of the judgment. In those circumstances, after this 3 year has been noted, this appeal is partly allowed by directing the respondent corporation to make a fresh assessment in relation to the period covered by prayer B of the writ petition on the basis of the observations made in this judgment within 8 weeks from the communication of this order, and raise final bills on the petitioner within a further period of 1 week, and realize the same as soon as possible, not later than 4 months from the date of service of this order. So, my lord, fresh assessment had to be undertaken. They cannot rely on, my lord, whatever was assessed prior to the judgment delivered by the Honorable Division Bench. They admittedly they have not carried out fresh assessment in terms of the Division Bench order, and admittedly, my lord, they have acted in terms of the Amendment Act of 2023.
And on a parallel scene, they pursued their legal remedies, challenging the order before the by way of a review and review petition, and then SLP. They did not even apprise the Honorable Division Bench that we have amended the act.
But the period of assessment, Mr. Carr, is the same period of assessment, which is starting from
Lord, the period of assessment that we have factored in here.
4 to 85, continue till 99 to 2000.
Yes, yes. Fourth
But that
quarter,
is-
84, 85 to
99, 2000.
that 2000.
This is the period of assessment.
Correct. Correct.
Today also, this is the period of assessment.
Yes,
Lord,
99.
this is the period of demand is based on that period of assessment.
Right.
But Lord, I am saying that
So your initial demand in the first round of litigation, where they have paid 1 crore 28 lakhs odd amount, is that period itself, right?
that period, yes, that period.
Today you have reassessed it
Yes.
and have come to a different finding and a different figure.
Lord, this subject to correction again by your lordship. 1 crore 28 lakhs that they had paid was paid under order of court, not based on the basis of any assessment.
Absolutely.
So, Lord, 1 crore 28, Lord, has been, that's my instruction again. But if your lordship wants with coming, I can come with better particulars, there is no difficulty. 1 crore 28 has been factored in this demand because the whatever payment they have made, that has been given credit
The
of.
demand must be much more.
Yes,
This is
obvious.
a figure which has been arrived by the court.
Correct. But Lord, I can come up with a breakup of the calculations if your lordship so desires. I am saying, Lord, as an interim measure, because we are not running away from your lordship, my lord will, a point has been raised that will have to be decided. Your lordship will decide that on affidavit. Lord, let them pay this money. Whatever the balance amount is about 3 crores, let them deposit.
You show me the calculation.
Calculation.
Very
Yes.
I
Show me the calculations.
Right, my lord.
Let me have a look at it. We'll keep it next week.
very well. Well, next week, Lord.
Next to next week.
Yes.
24. Nobody's running
Your
away.
lordship kindly takes page 52.
Sir, Mr. Majumdar.
I'm sorry.
What we'll do is,
Yes.
let them come up with the
Yes,
calculation.
yes.
Let me have a look at it.
Yes, certainly, my lord. Certainly.
We'll keep it on 24.
24th. Grateful.
Mr. Carr has some
Yes, yes.
difficulty on.
But we all have difficulty next week.
I
I do not know whether your lordship. Me too.
This is a Me Too situation.
Can it be 25th, my lord, subject to your lordship?
I keep all matters on 24. Original side is on 24.
Whenever it
But
is
here the parties are at item, my lord. We are just
no, but it is limited to this Lord calculation.
right.
Lordship will,
Limited to
my lord can
calculation.
give a direction for filing affidavit. We'll come back to your lordships on the limited question of calculation and Lord question of interim payment.
Correct.
The petitioner has preferred the present writ petition seeking issuance
But
of.
can
writ
it
of-
be? Can it be, my lord, the Thursday after 24th, subject to your lordship's kind consideration?
I can, not a problem.
Not a problem.
For me also no problem. Just check out.
Because my junior will be in some days a personal.
First of May.
First of
First of May.
petitioner has preferred the present writ petition seeking issuance of writ of mandamus declaring section 3 of the Calcutta Municipal Corporation Amendment Act 2022, which seeks to substitute a new clause D to subsection 2 of section 179 of the KMC Act 1980 as unconstitutional. The petitioner further challenges the demand raised by the respondent corporation wide letter dated 23/7/2024 for a sum of rupees 11 crores 24 lakhs 27,669. Full stop. Mr. Senior Advocate Mr. Carr, who appears for the Calcutta Municipal Corporation, states that they shall bring the breakup of the demand which has been raised on the petitioner on the next date of hearing. Full stop. Let this matter be listed. I'm not giving a direction for affidavit. Let this matter be listed on 1st of May. Full stop.
Grateful, man.
I'm keeping this list of date, Mr. Majumdar, in the file.
So great. Man, we'll keep.
Good.
Pass over matter item number 9.
Sorry, in the first call, I just got stuck in another court. I didn't take a break. Yes, please. I'll just come back in 5 minutes. Yes, sure.
a prior debt. That is, my lord, and a prior debt which includes a debt of a local authority also. That is the subject matter of consideration, my lord.
Correct.
So here my case is that, my lord, the first impugned notice seeks to, my lord, if your lordship takes 4th of June,
Page
234.
it's all black. Yes.
233.
233.
233 is the first notice which I am challenging. It seeks to propose annual valuation under the unit area assessment scheme with effect from first quarter 2017. And the annual valuation is proposed under section 174. And the subsequent notices are intermediate revision. Because once an annual valuation is assessed, it has to valid for a period of 5 years. On special grounds under the statute, it can be revised on an intermediate period between that 5 years. That is what the corporation has sought to do by the subsequent notices. But all are dated 4th June. Primary point of challenge centers around the first notice, because the subsequent intermediate revision is based on the assessment with effect from first quarter 17. If that assessment they are not capable to do, authorized to do under the Act, then the subsequent intermediate revision will also be nullified, because they are taking first quarter 17 as the base period. Now, my lord, if I come back to the first notice, why I say the first, they cannot make assessment with regard to first quarter 17. This unit area assessment scheme came into effect on and from 1st April 2017, undisputed. Now, if that is so, at that point of time, this entity was not under CIRP. It was in operation. So there was no legal impediment on or bar to foist liability on the basis of unit area assessment scheme when it came from 1st April 2017. That was not done. Then what happened, my lord? There are few dates which are important, my lord. This CIRP started on 8th October 2021. That is the date when moratorium set in under section 14.
Yes.
And 11th August 2023 is the plan approval date. These are, my lord, admitted position, matters of record. I have annexed the orders in my petition. So, my lord, the claim is for the period first quarter 2017, which is being made on 4th of June 2024, retrospectively. Why it is being made now 4th of June 2024? Because, my lord, that period is now over. They have realized that this claim could have been made earlier, but was not done. It's a different question whether if it is a case of a running company which had not gone into CIRP, whether they could have done it for how many years retrospective operation was permissible, that is a different question. But today, in case of this company, under the provisions of IBC, does the provision of this new code, which overrides all other provisions of law, would permit them to make this valuation assessment on a retrospective operation from first quarter 2017. Now, my lord, I'll just say first, I will show your lordship. First is, my lord, property tax, whether it is covered. I'll just. ঠিক আছে তাহলে মিলে যাবে বার করে দিই দিন আমি বার করে দিই 521.
Property tax covered under IBC.
Yes.
I
My
think
submission is it is falling under operational debt.
520
Kindly see 5's definition, subsection 20 and subsection 21 of this section 5. Operational creditor means a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. Operational debt means a claim in respect of the provision of goods or services, including employment, or a debt in respect of payment of dues arising under any law for the time being in force, payable to central government, state government, or local authority.
I think that Justice Oak's judgment in Vaibhav Goel takes care of.
Yes, yes.
That's
yes. Now, my lord, once this falls under a category of an operational debt, then your lordship will kindly see section 31. That is binding effect of the plan on whom? Yes.
520.
Yes, 520 that is seen, shown. Before your lordship comes to the section 31(1), let me show your lordship, my lord.
30 or 31?
31.
31.
31 before that, your lordship will kindly take section 13 once first.
13.
13. Declaration of moratorium and public announcement. Adjudicating authority after admission of the application under 7 or 9 or 10 shall by an order declare moratorium for the purposes referred to in section 14, cause a public announcement of the initiation of corporate insolvency resolution process, and call for submission of claims under section 15. So, the order of the adjudicating authority will include the direction for public announcement by which the corporate insolvency process is initiated, and that public announcement calls for submission of claims. Kindly see section 15. Public announcement of corporate insolvency resolution process under the order referred to in section 13 shall contain the following information, namely, A is the corporate debtor, B is the authority which corporate debtor is incorporated, C, last date for submission of claims may be specified. So this is by way of public notice. Then your lordship will kindly see, thereafter, my lord, comes 31.
Yes. Creditors including central government and state.
Yes.
Or any local.
If the adjudicator is satisfied the resolution plan is approved by the committee of creditors under subsection 4 meets the requirements, it shall by order which shall be binding on these persons. Binding on the corporate debtor, employees, members, creditors. Your lordship has already read it, including the central government, state government, or any local to whom a debt in respect of payment of dues arising under law for the such as authorities to whom statutory dues are owed. So, my lord, this is the scheme of the act. Now, my lord, apropos the question which fell from your lordship on the last day, what happens if a local authority has not come forward with the claim? But the Supreme Court has given a justification for this reason, because a resolution applicant who presents a plan, he presents a plan on the basis of the liquidity status of the corporate debtor as on the date when the plan is presented. He must be told that these are the liabilities which you will have to undertake. Today, at the time of presenting my plan, I am told that there are A, B, C, D, E liabilities. I make a plan accordingly to provide for that. The committee of creditors will thereafter approve my plan based on my making provisions for the creditors, my lord, and the dues of the company. Now, my lord, say, my lord, my plan is approved, and I take over this company.
Right.
Suddenly, my lord, a claim comes for that past period when the CIRP process is going on.
Or even pre-CIR.
Or even pre-CIRP, my lord. That is saying, my lord, I will be taken by surprise because my plan, it is
factored that.
Yes.
The new management.
The new management who is now taking over, he is taking over with the liabilities. He must know what the liabilities he has to take over. So, my lord, that is why, my lord, the Supreme Court, my lord, in these judgments have come up with this, saying that whoever takes a going concern takes it with a clean slate. Unless the claim is adjudicated, there is no claim, there is no past claim which he can be bound or made liable to take over.
Right.
Yes, my lord, my learned friend gives the correct expression, my lord. So, my lord, if I now directly go on, my lord, to the judgment of the Supreme Court, my lord, in this regard. প্রথমটাই তো 21.9 SCC টা।
Which one? 2025 SCC?
No, first is 21.9 SCC. This gives a very 2021.9 SCC 657. Paragraph 65 টা বার করুন। And I have in fact, I am will be placing from paragraph 65 of the judgment. We're at page 698. May I please? A bare reading of section 31 of the Insolvency Bankruptcy Code would make it abundantly clear that once the resolution plan is approved by the adjudicating authority, after it is satisfied that the resolution plan is approved by COC meets the requirements as referred to in subsection 2, section 30, it shall be binding on the corporate debtor, employees, members, creditors, guarantors, and other stakeholders. Such a provision is necessitated since one of the dominant purpose of the INB Code is revival of the corporate debtor to make it a running concern. Then 66. Resolution plan submitted by successful resolution applicant is required to contain various provisions. Provision for payment of insolvency resolution process cost, provision for payment of debts of operational creditors, which shall not be less than the amount to be paid to such creditors in the event of liquidation of the corporate debtor under 53, or the amount that would have been paid to such creditors if the amount to be distributed under the resolution plan had been distributed in accordance with the order of priority in subsection 1 of section 53, whichever is higher. Resolution plan is also required to provide for payment of debts of financial creditors who do not vote in favor of the plan, which shall also not be less than the amount to be paid to such creditors in accordance with subsection 1 of section 53 in the event of liquidation of corporate debtor. Explanation 1 to clause B of subsection 2 of section 30 clarifies for the removal of doubts that the distribution in accordance with the provision of said clause shall be fair and equitable to such creditors. The resolution plan is also required to provide for management of the affairs of the corporate debtor after approval of the resolution plan. Then your lordship can kindly read 67 and 68. Perusal of section 29 of the code read with regulation 36 would reveal that it requires the RP to prepare an information memorandum containing various details of the corporate debtor so that the resolution applicant submitting a plan is aware of the assets and liabilities of the corporate debtor, including the details about the creditors and the amounts claimed by them. It is also required to contain details of guarantees that have been given in relation to the debts of the corporate debtor by other persons. Details with regard to material litigation, ongoing investigation by the statutory are also required to be contained. Then 68, all these details are required to be contained in the information memorandum so that the resolution applicant is aware as to what are the liabilities that he may have to face and provide for a plan which, apart from satisfying a part of such liabilities, would also ensure that the corporate debtor is revived and made a running establishment. Legislative intent of making the resolution plan binding on all the stakeholders after it gets the seal of approval from the adjudicating authority upon its satisfaction that the resolution plan approved by COC meets the requirement as referred to in subsection 2 of section 30 is that after the approval of the resolution plan, no surprise claims should be flung on the successful resolution applicant. Dominant purpose is that he should start with fresh slate on the basis of the resolution plan approved. This aspect has been aptly explained in SR Steel. Kindly see, my lord, thereafter, paragraph 107, which is quoted in para 69, just after 5 lines from the top, which starts with a successful resolution applicant cannot suddenly be faced with undecided claims after the resolution plan submitted by him has been accepted, as this would amount to a hydra head popping up, which would throw into uncertainty amounts payable by a prospective resolution applicant who would successfully take over the business of the corporate debtor. All claims must be submitted to and decided by resolution professionals so that a prospective resolution applicant knows exactly what has to be paid in order that it may then take over and run the business of the corporate debtor. This, the successful resolution applicant does on a fresh slate, as has been pointed by us herein above. Then kindly come to 71.
Section 238.
Supreme Court, my lord, relies upon section 238 of the IBC, which is the overriding section. (238) says provisions of this code to override other laws. Provisions of this code shall have effect, notwithstanding anything inconsistent therewith contained in any other law for the time being in force, or any instrument having effect by the virtue of any such law. Now, it will be in page 180 of that book, Bear Act.
180.
180. So, my lord, based on this, this provision was considered in Monet Ispat and Energy Limited as my lord, noted in paragraph 71 of the judgment. There it says, in view of the provision 238 of the IBC, provisions thereof will have an overriding effect if there is any inconsistency with any of the provisions. Now, kindly see paragraph 73 and 74 is very important because, my lord, 31, the last part, including the central government, any state government or any, that has been amended, incorporated by way of amendment. Previously, it was not there. So, considering that, and that came with effect from 16th of August 2019. So, this amendment has been considered in para 74 and it says, as such, with respect to proceedings which arise after 16th August 2019, there will be no difficulty. My proceeding is after 2019, started in 2021. After the amendment, any debt in respect of payment of dues under any law for the time, including ones owed to central government, state government, or any which do not form a part of the approved resolution plan, shall stand extinguished. Now, so, my lord, thereafter, your lordship sees this has been at 2020 to the
2022. 2028 judgment.
Yes, well, I'm not formally once again citing that SR Steel, which is already quoted here. And I'm giving your lordship a copy of that. একটা copy দিয়ে রেখে দিন।
2020 volume 8
হ্যাঁ।
541 para 107.
Lordship can kindly note, well, I am once again relying on this paragraph 107. I am not placing
One
it,
which has been.
which is quoted in
quoted.
paragraph 69. Now, the other one, my lord, which I am now relying upon, which is again directly relevant for our purpose, is 2022 6 SCC 343.
Ruchi Soya.
Yes. Kindly see once, my lord, paragraph 6. Short point that is involved is as to whether claim of the present respondent, which was admittedly not lodged before the resolution professional after public notices were issued under 13 and 15, could be considered at this stage. Kindly come to paragraph 10. We find that the present appeals are squarely covered by the law laid down by this court in Ghanshyam Mishra, which I have just now placed. 102.1,
Yes.
102.2. These are the. Then, my lord, paragraph 11. Admittedly, the claim in respect of the demand, which is the subject matter of the present proceeding, was not lodged by the respondent number 2 after public announcements were issued on 13 and 15. As such, on the date on which resolution plan was approved by NCLT, all claims stood frozen. No claim which is not a part of the plan would survive. In that view of the matter, appeals have to be allowed only on the claim of the respondent, which is not part of the, does not survive, amount such and such. And has been directed to be refunded, because as an interim order, it was directed to be deposited. That has been directed to be refunded now. Now, my lord, kindly see. So therefore, my lord, this is the short issue, my lord, which
18 CC 786.
Yes. One more, my lord, just on the consideration of section 238 IBC.
Income tax. Income tax law.
Just one page, my lord.
18 SCC 786.
This is, my lord, 2018 18 SCC 786.
Yes.
18.
Given section 238 of the IBC, it is obvious that the code will override anything inconsistent contained in any other enactment, including the Income Tax Act. Income tax dues, being in the nature of crown debts, do not take precedence even over secured creditors who are private persons. This is actually a special code for revival of the corporate debtor.
Yes.
Paragraph 5 and 6. 5 and 6 to put it to order last 406. Resolution plan and
now, my lord, kindly see also, my lord, who is the successful resolution applicant? Who am I? I am a consortium of financial creditors. This is a central government undertaking. This is NARCL, National Asset Reconstruction Company Limited. This is the entity who has been now successful and whose plan has been approved. And we have taken over this corporate debtor, this RAI. So, my lord, I am not a private person. I am also a consortium of the creditors, fully controlled by the government, nationalized banks, my lord. And, my lord, this is a statutory provision. There cannot be any.
I'll just add one more judgment for your friend. See this. The latest one. Para 8.
Para 8. I am obliged. We are lacking in homework. This shows.
He's lacking in homework.
No, we.
You're senior. You're only making money now.
Eight. Paragraph 8. You have the
We have relied on all the same judgment.
2020, yes. 2025.
This is the latest.
Yes.
I'm grateful, Munad, and I do
Lord-
apologize.
Lordship is doing more research than we are. This is the list.
Quoted Ghanshyam and
Yes,
the
yes, yes.
come to the same point. That pertains to
And this is to relating to income tax dues.
Income tax.
Income tax dues.
So the assessment has been quashed.
Yes. Obliged.
Grateful.
I'll just take note of.
I mean,
Just make a note of it and
yes.
SC 592.
yes.
So, my lord, I rest my case here, my lord.
Yes, Mr. Mukherjee.
So, my lord, the valuation is bad. Not a single sentence uttered so far as the valuation is.
তাহলে তো বলবে appeal করো।
And that notice at 234, from which everything emanates, is not under challenge, at least from the arguments of Mr. Singh.
Yes, that is
আমি একটা কথাও বলিছিলাম,
আমি তো ওকে বলছি।
আসতে বলে। Now, ultimately what boils down to debt and claim. So I cannot proceed with the debt and claim against this person. That is in terms of IBC. So it is the ultimate is that you cannot proceed with the debt and claim. Now, my lord, first I would start from page 1. Your lordship sees who is the petitioner before your lordship.
Yes.
I'll address on these points just after 5 or 10 minutes.
Yes.
My lord would kindly come to page 1 of the rather the cost title. The petitioner before your lordship is Srei Infrastructure Finance Limited, 1, and 1 Sohan Kumar Jha, Dhirendra Kumar, son of so working for gain.
Yes.
Srei Infrastructure. Now, my lord would kindly take up, comes to page 4, para 1.
Yes.
After giving details of petitioner number 1, petitioner number 2 has been duly authorized. My lord would kindly note this.
Yes.
Authorized by the board of directors of the petitioner number 1 company to join and represent in the recently petition. So, Srei Infrastructure is the petitioner number 1, and the board of directors have authorized this petitioner number 2 to prefer this writ petition as such this writ petition. Now, my lord would also take para 4. The petitioner number 1 is a non-banking financial corporation having license under the Reserve Bank. I am now not
The next slide doesn't proceed.
yes. Comes to paragraph 5. Oh, sorry. 4. On October 4, your lordship would mark it. On October 4,
Where, Mr. Mukherjee? The next October 4th.
Reserve Bank of India superseded the board of directors of the petitioner number 1 and had appointed administrator in respect of the petitioner number 1. So, my lord, subject to correction by my lord, the board of director has become defunct. In terms of October 4, 2021, Reserve Bank of India's resolution, superseded the board and appointed an administrator. If that be so, my lord, whether the board has or had, after the Reserve Bank of India's order on 4th of October, any authority to appoint XYZ to move this writ petition. My lord, I ask a question to myself. Now, my lord would come to paragraph 6. A resolution plan proposed by the National Asset Reconstruction Company came to be approved by the learned adjudicating authority under IBC on August 11, 23. Upon approval of the resolution plan, all claims demands against the petitioner number 1 up to August 2023 stood extinguished. That is his case, and that is what he has argued before your lordship now. Now, two things are also important. The petitioner is the owner of the building, and he has also inducted licenses or tenants, whatever one says, and they are paying taxes. Rent. And other thing is, he is enjoying the civic amenity. This property tax is a tax which the civic authority collects to defray the cost and expenses of the civic amenities, what I provide to the various assessees and the house owners in the building. So I have provided that civic amenity to this building and this person without knowing that he is a defaulter and he has been an adjudged defaulter. Now, my lord would kindly take the trouble of coming to the first order which your lordship gets.
Page 32?
Yes, my lord, page 32. I am grateful to my lord. Now, my lord, here also, all the details at page 34 is given. RBI with a notification number so in exercise of powers under so has superseded the board of directors of SIFL and appointed Rajnish Sharma as the administrator, and it has also constituted a 3-member advisory committee to assist administrator of SIFL in discharge of its duties. The RBI has proposed the same person to be appointed as the administrator of the corporate debtor. Now, my lord, paragraph 8 only for the purpose of information. This was under challenge. Mr. Swenso, learned counsel, further submitted that a challenge to the notification of 4/10/21 issued by RBI in our writ petition number Swenso was dismissed by Bombay High Court with an order dated 17/10/21. Did my lord get it?
Yes.
Now, my lord would again see the repetition of this at paragraph 13, 14. And 15. The same thing has been reiterated. So it is very clear that the board of directors who has appointed this petitioner number 2 to prefer this petition has no authority. It is defunct. On the day the writ petition was being affirmed and filed, unfit person. That is one. Now, my learned friends, the basic is claim and date. My lord, here I just say two things. A date or a claim. A property tax becomes a debt or claim when my lord, I ask a question to myself. First is, my lord, a notice of hearing which is given, which is at page 234, which my learned friend has referred to. After a notice is given, a date of hearing is fixed in terms of that notice. And in that notice, it is clearly stated, please give your objection to the proposal of the valuation because it is based on rebuttable presumption. I propose you have to come forward. Law enjoins that. It can be done. Rebuttable presumption. I propose you have to come with the best evidence and objection that your proposal is bad. Once that is not done, the proposal is through and it attains finality. And once it attains finality, then I issue tax bill.
Yes.
Thereafter, if the tax bill is not paid, then it becomes a due or a claim of the civic authority. So this determination of valuation, not a single word uttered that it is bad. He cannot do also because of the fact.
But he's not challenging it.
He has not challenged it ever. When I given the notice, there was no letter saying that your proposal is bad for A, B, C, D, E. Not done. Not done. Now that proposal is through. Now, so far as the latter part of the Mr. Sen's mainstay of the argument, your lordship would now come to.
If I take that argument, then the assessment which has been carried out by you, after the assessment, you could have raised the demand. You could have realized the demand. The demand could have always been realized. I'm sure the property tax can be realized in the form of a, attachment or distress warrant you could have issued.
Those provisions are there in my
You
act.
chose not to do anything. You chose not to do anything. Nothing was done.
It has been done. This determination of valuation has been done recently. I'll show why it has been done recently. I'll just show it. But what he is saying now, that will also melt in the thin air. I'll just show it. Malad would straight away come to page 198. This is again a continuation of an order of. It is again a continuation of an order of National Company Law Tribunal, which starts at it starts at page 48. The first one is 32, which my lord was referring to. Then my lord would kindly come to page 48. This is the order of NCLT 11/8/23, page 48. Did my lord get it? Now my lord would kindly come to page 198. It is continuation of that. 198. 198. My lord, he was arguing he was saying it very clearly, as I have heard. The resolution applicant should not be taken with surprise. These are all Hydra heads popping up. Now, what did the resolution applicant pray for before the adjudicating authority? I will not trouble much. Your lordship would just cursorily see 199 relief with respect of Central Board of Direct Taxes. Did my lord get it?
199.
These are page 199, top heading, relief with respect to Central Board of Direct Tax. Did my lord get it? Then my lord would turn to page 202. This is his second relief. relief with respect to Central Board of Indirect Taxes, Customs, Ministry of Finance of the relevant state government and union territories. My lord, that's now, my lord, would kindly come to page, yes, 205. 205. Relief with respect to the regulatory framework, relief sought under the Companies Act 2013, then 206, other reliefs. There's a head of other reliefs. Other reliefs, my lord has got it, page 206.
Yes.
Now, this is, my lord would kindly, after all this, it is not very relevant for us. My lord would kindly come to page 222. Paragraph 115. May I please it, my lord? I'm reading it for your lordship. We have perused.
100 and sorry, which one?
My lord, page 222. Para 115.
Before you go there, Mr. Mukherjee, if you see page 202.
202.
202.
Yes, my lord, I'm coming.
Relief for indirect taxes and custom, Ministry of Finance
Yes,
and relevant state
yes,
government. And
yes.
so here to provide to the corporate debtors such that all pending litigation notices, past and ongoing assessment and audits, past and ongoing investigation, tax demand under all indirect taxes, including but not limited to set out in Annexure 10.
Yes.
So probably this tax should also be part of that.
No, no, it is not. I'll just show it. That is the reason, my lord, I'm drawing your lordship's attention
State. All
to
pending.
page 122, para 115. We have perused the reliefs, waivers, and concessions as sought and as given in section 10 at pages 105 to 115 of the resolution plan. While some of the reliefs, waivers, concessions sought by the resolution applicant come within the purview of the court, while many others fall under the power and jurisdiction of different government authorities, departments. This adjudicating authority has power to grant relief, waiver, concession only in relation to the code and the Companies Act. For achieving the objective of the code, no relief, waiver, and concession that fall within the domain of other government department and authorities are granted. Then the reliefs, waivers, concession that pertain to the other government authorities, department shall be dealt with the respective competent authority, forum, offices, government or semi-government of the state or central government with regard to the respective reliefs, waivers and concessions. The competent authorities, including appellate authority, may consider grant such relief, waiver, concession, keeping in view the spirit of the code. My lord, pausing here for a second. I'll just pausing here. My valuation is intact. Even if I take Mr. Sen's argument on face value, what goes is my subsequent demand based on the valuation determined. Valuation determined. And if he says that this is a challenge to the valuation, go before the tribunal. Go before the tribunal, because there you have to show these are the grounds why your proposal is bad. Now, since there is no challenge to that, this cannot be turned into an appeal to the determination of valuation. So I have shown the parameters of what did he ask for, from the adjudicating authority and what the adjudicating authority has adjudicated. Now, my lord would kindly come to page 224, the paragraph 124, the moratorium imposed under section 14 of the code shall cease to have effect from the date of this order. It ceases. Today there is no moratorium. Now, the gamut of his challenge and the entire gamut of his argument relating to the claim and date is an act subsequent to the determination of the valuation. Determination of valuation doesn't go away. If at all, if I take Mr. Sen's argument on the face value, but I have shown my lord the document, what were the reliefs and the waivers and the concession was being asked for. This doesn't form a part of that seeking concession, waiver and all that. What the authority says that so far as the other authorities and all these are concerned, you go before that authority and seek your relief. But my lord would kindly keep in mind, for all these years, when these proceedings were going on, I provided him water, I provided him a clean road, I have provided him a swearage, and he was earning money from his tenants at my cost. At my cost.
We'll have it next week.
Next week.
Next week.
My lord, only thing, my lord, would
Not 17th. We won't
my
have
lord,
it.
kindly,
17th.
I apologize.
No, I have.
My lord, would pardon my impertinence.
I also have problem.
And then, my lord, if your lordship says that, then, my lord, I need not mention the other matters which are appearing in the hearing list because I need not be there.
Let's just matter for further hearing on 24th.
Yes, I'm great.
24th.
এই আপনি কি এটা নিয়ে নেবেন কোনটা এটা এই পিটিশনের সেকেন্ড পার্টটা না ওইটা নিয়ে
We'll have it on.
Malad, may I take one indulgence?
Yes.
Subject to Malad's approval, Malad.
Wrong time for indulgence, but
Malad, sorry, whatever Malad will say, that will be very important. Malad, only thing, Malad, I am seeking. Malad, I know, I have heard that Malad on from 24th, Malad, regarding hearing matters, original side. Malad, already it was fixed by another honorable court judge at 2 p.m. But Malad has have to hear.
Today, don't worry.
No, today not today. I am not saying that. Referring to 20. Malad, already it was fixed by another honorable civil judge, but now the determination was changed. While Malad is now getting that determination. Malad, what I am on, Malad, I have heard that on from 24, Malad will take regarding hearing matter will be taken up first half or second half regarding.
We are taking original side matters
Yes.
on 24th, so don't worry about it. No change.
24, that is hearing. Malad is taking up the motion.
Yes.
What I am on.
Yes.
Kindly give one half only or second half or first half. So for hearing matter is concerned, so that my matter can be taken up and others.
Let me come.
Kindly already it I will come up and I will mention on 24. That will be my lord.